Court does call the cases of, well, Arbor One and Arbor One West, but I'll call the case of Arbor One West versus Rico McGuire. Counsel, state your affairs.
Who asked if you're independent?
All right. All right. Where are we now on this? Who wants to start? You don't want me leading off, but go ahead.
I'm sorry.
I said you don't want me leading off, so I'll let whoever wants to start.
You're examining witnesses. That would be wrong.
Correct.
There are a few left. Trying to testify in person.
Correct. Are they here?
Ms. Carson, I think we left off in the middle of her testimony. She's not able to be here this morning. She's at school. And I think we asked her all the questions that we needed to at the moment, whether there's some development there now.
Right. And then some issues were brought up, as I recalling. So of the 17 individuals, was there anybody in Zoom? No. Of the 17 individuals, was there anybody else here that needed to or wanted to testify? That's here of the list you gave me.
So, Your Honor, Rico McGuire is not a defendant in any of these cases.
Correct.
And we did take testimony from her. There was a development in her situation that I thought the court had to take testimony about. Otherwise, I think we would like to ask city officials to testify.
Okay. All right. We'll get. Okay.
If you think this is just another routine landlord-tenant hearing, don't get too comfortable. What starts as a simple discussion about who is available to testify is quietly setting the stage for something much bigger. Judge Simpson isn't rushing ahead or making assumptions. He's carefully identifying every witness, every missing person, and every potential piece of evidence before the court hears the real allegations. That patience matters, because cases involving housing conditions often turn on credibility. Documents matter, inspections matter, but first-hand testimony from the people who actually lived through the conditions can completely reshape a courtroom's understanding of what happened. Notice how the judge pauses to confirm who is present, who is relocated, and who still needs to speak. That may sound procedural, but it's actually laying the foundation for fairness. Nobody can later claim they weren't given an opportunity to be heard. As more tenants begin taking the stand, the focus will shift from administrative details to deeply personal stories involving living conditions, relocation, and the responsibilities of a landlord. And that's where this hearing becomes far more than a paperwork dispute. As you watch, ask yourself this: if multiple unrelated tenants begin describing similar problems, does that strengthen the credibility of each individual account? Keep that question in mind, because the testimony you're about to hear will start revealing whether these complaints are isolated incidents or part of a much larger pattern.
And Your Honor, I know that you said you're here as a treatment. What did you experience?
Okay. So that was number 8 on the list that I had. Miss Freeman Harris. Okay. Any of the others that I had that did not was Joseph Blankenship, Erica Reed. Then there were a number of people that I believe wanted to testify via Zoom, but
My report showed that both Blankenship and Reed were relocated.
Blankenship and Reed were relocated. Then there were, I guess, some other So right now, the only person is Miss Freeman Harris that you guys are aware of.
That's right. Your Honor.
Okay.
Oh, I'm sorry, Your Honor. I just learned that Miss Griffith is here, Regina Griffith.
Oh, she's here. Okay, I had her as one that was gonna by Zoom. Okay. All right. And then as with everything, we ran into an issue that may have specifically related to Beal. And you're here representing Beal, I'm presuming. Pardon?
I said that's right here.
Okay. And what may be some potential issues regarding, at least based upon the testimony and the relocation of individuals and the like. Okay. All right. So, we ready to continue? I guess since Miss Griffin is here, we could start with her. That would be acceptable to everybody?
That's fine.
All right. Ma'am, if you please come forward to be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
See, state, spell your first and last name for the record, please.
Regina Griffith, Regina, last name Griffith, Griffith.
You may inquire. Ma'am, where do you reside?
I was in building 1427 in apartment 117.
1427-117. Okay, thank you. All right, Mr. Freeman.
Where do you reside now?
Homeless.
That single answer changes the emotional weight of this hearing almost instantly. Up until now, the discussion has revolved around witness lists and courtroom procedure. But with one word, homeless, the case suddenly shifts from abstract legal arguments to real human consequences. Judge Simpson immediately pivots away from routine questioning and begins exploring how this witness reached that point. Instead of assuming anything, he starts tracing a timeline: when she moved out, why she left, what notices she received, and how the housing process unfolded. Those details aren't just background information. They're essential to determining whether the housing conditions, the landlord's actions, or other circumstances contributed to her current situation. The judge's questions show that he isn't interested in dramatic claims alone. He wants facts that can be verified through testimony and documents. This is also an important reminder that courtroom proceedings often move slowly for a reason. Before assigning responsibility, the court has to understand the sequence of events. Who knew what? When did they know it? What actions followed? Those questions may sound repetitive, but they're exactly how judges separate allegations from evidence.
Excuse me? You're homeless?
Have it.
Well, have you requested relocation?
I didn't know what was going on right away because my apartment got, the housing commission shut it down because it wasn't livable. And I had to move out by June 30th last year. And then I had this on the news and stuff. My daughter told me I immediately got letters. I wasn't receiving them because Amy was telling Melanie to get my mail and put it up in the office. So I missed all that.
So, when did you vacate 1427 unit?
June 27th. Like I was told by the housing commission.
What, the Hanover Housing Commission?
Yes. I have to reach you.
We have no information under your.
What? So, ma'am, when you were told to, let me ask this. What was the reason they told you that?
There was a few. I have the list that they were supposed to have the stuff fixed by a certain time. They did. And they gave the second notice and then the third notice. They wasn't being great no more than I had to about.
But these buildings were not, they still had a COC on you. So
No, they didn't.
Well, in June, I thought they may have, but, um, but maybe that's part of the problem. Part of the problem may be the buildings had COCs because they hadn't been inspected. And I mean, it doesn't mean that the conditions didn't exist, right? I mean, and that's what it sounds like
Well,
here. If the COC existed, it was the prior COC, but her unit,
It's horrible.
well, Your Honor, I guess to be blunt, we have never seen anything from her indicating that she was ordered to vacate. She wasn't ordered by the court to vacate. If she lost her voucher, that might be a different issue.
can I
The
see?
several times I came to court, she tried to sue me $4,000.
So, ma'am, at the time that you were there, what was your rent, your portion
My portion was 165.
a month?
Yeah, correct.
And then the rest of that, the housing commission paid.
That is correct.
Now the financial picture starts becoming much clearer. Judge Simpson isn't just asking what the tenant personally paid each month, he's identifying how the rent itself was structured. According to the testimony, the witness paid only her portion, while the housing commission covered the remaining amount. That distinction could become extremely important later because it separates the tenant's personal payment obligations from any broader payment issues involving housing assistance. It's a subtle but critical legal point. If the tenant consistently paid her required share, then later disputes about unpaid balances may require much closer examination. The court will eventually have to distinguish between what the tenant herself allegedly owed and what might involve housing assistance payments or other financial complications. Watch how methodical the questioning is. Rather than jumping directly into accusations about unsafe living conditions, the judge first establishes the financial relationship between the tenant, the landlord, and the housing authority. That foundation makes it much easier to evaluate later testimony about notices, repairs, inspections, and payment records.
Okay, how long had that been the one, excuse me. How long had you been paying 165?
I lived there for 3 years.
And that's been your rent for,
Yes.
okay.
Yes.
So it hadn't changed really throughout, or if it did, it wasn't a
Well,
lot.
right after they got the, letter from the housing commission, I had contacted Amy because they kept saying that they were gonna have maintenance come in and fix stuff. So I was having my daughter come over because I was leaving. My mom was in the hospital at the time, but they would never show up. So I had called Amy and asked Amy, and Amy was like, well, I don't know what's going on. I'll figure it out. And she never figured it out. So that's where the issue was coming. And then finally, she's like, I'm not fixing your apartment. I'm not doing anything to your apartment. If you want to move out, you can move out. I'm not doing nothing to your apartment.
When was
And she
that?
charged me $300 extra. Then she charged me $200 for month to month. But that wasn't my fault either. And I had that
Well, when did that happen?
right after housing commission shut that building down. And I had approval in my file.
So what is 6 times 165? So in May of 2024, you were still residing there. But at that time, the housing commission hadn't shut off pay.
Right, they were giving them warning after warning, giving them chances after chances to fix the issue, and they just never tried to.
Okay, but I'm looking, I guess, at timing of that. Do you have those notices? Why don't you go get those? So my question to you is, in May of 2024, had Arbor One received notice? Pardon?
Yes,
Okay, what do you have to tell me? Okay, What do you show? What is
This
this?
is the letters that they received from the housing commission. I received one, they received one.
So this is a series of letters
Mhm.
throughout. Okay, and need you.
When I first moved in, they already knew about the issue because I filled out we walked in,
Who knew about the issue?
everyone, Amy and, Stacy. I sent a video because it started raining in my house on the third night that I was there. So it's an ongoing issue, but they never cared about it.
When you say there was an ongoing issue, what do you mean?
I would call up there and do the maintenance orders. They canceled the maintenance orders. I have proof of that too. We just got, they didn't care to do anything.
Okay, what kinds of things?
My ceiling, finally.
Go ahead.
Finally, the ceiling fell through. So water was coming from the ceiling onto the floor, onto the carpet. And it flooded my bag where all my stuff was, all that got removed. Then it started coming out of the walls. And then the bathroom overflowed with sewer water all over the place. So we went through 2 carpet cleaners cleaning the stuff up. And then the stove almost caught my house on fire.
Hold on a second. Did they fix the ceiling?
No.
At this point, Judge Simpson's questioning becomes much more focused, and for good reason. Up until now, the witness has described repeated maintenance requests, water intrusion, overflowing sewage, damaged carpeting, and even concerns about fire hazards. Rather than allowing the testimony to become a list of unrelated complaints, the judge pauses to isolate one issue that could reveal whether meaningful repairs were ever attempted. That's an important courtroom technique, because establishing a clear timeline of reported problems and responses helps determine whether the property owner simply faced difficult maintenance issues or whether there was a continuing failure to address serious living conditions after being put on notice. Notice that the court isn't making a finding yet. The judge is still gathering facts, one problem at a time. Every answer becomes another piece of evidence that can later be compared against maintenance records, inspection reports, photographs, or testimony from other witnesses. That's how credibility is tested in court, not through dramatic statements alone, but by seeing whether independent evidence supports what each witness says happened.
Right now, it's still like that, or it was like that. I have everything you need, Your Honor.
So, and we'll get the documents back. So you had the ceiling, you had other water, sewer water, and anything else?
So the carpet was it was black mold. I ripped the carpet out because they were supposed to come and fix it. They never, probably to this day, it's not fixed. And it was bad. It was a bad living situation. Bad.
Okay, so who was in your unit? You?
Me,
Just you?
yes. And then I would have my daughter come over when they wanted to come in and do the maintenance. Supposed to do the maintenance, but they never came. Never came. And that was going on since July. I moved in July 24, from July 24th
Of 2023?
of 2022.
22.
Yeah, till
Okay.
I just moved out in June. That would be 24.
Okay, so and you moved out because the housing commission said you had to. Okay, so you had a voucher. Where's the original of that? That's it. So you had that's hers. And so you had a voucher, right?
Yes, sir.
Do you still have it?
From what my understanding is, because I work with SOS too, Grace, and she was trying to help me through all this too, but the communication to R1 and the House Commission, I was supposed to have a movement packet, and I never received it because Amy was taking the mail from, and having the mail and take it to the office. So I never received any of my mail. So finally I ended up calling to find out what was going on. I have documents of that too. And they said that just keep looking for a place. I'm still looking for a place.
Okay, so as you sit here today, you believe that you have a voucher.
Yes.
Okay, but you're homeless at this point.
This exchange highlights one of the most emotionally significant moments in the hearing. After walking through months of testimony about maintenance issues, housing assistance, relocation, and communication problems, the judge brings the discussion back to the witness's current reality. According to her testimony, she believes she still has a housing voucher, yet she is also explaining that she remains without permanent housing. That contrast immediately raises larger questions the court will continue exploring throughout the hearing. Judge Simpson isn't simply reacting emotionally. He's identifying the practical consequences that may have followed the events being described. A courtroom has to move beyond sympathy and determine whether there is evidence connecting those circumstances to legally significant actions taken by the parties involved. That's why the questioning continues instead of stopping at the emotional impact alone. It's also worth noticing the pace of the hearing. Rather than rushing toward a ruling, the judge repeatedly asks follow-up questions designed to clarify dates, documents, and responsibilities. Those details often become just as important as the testimony itself because they allow the court to compare personal accounts with written records.
Can't find nothing. When you fill out the application, you gotta explain why I moved from R1. No, you can't even explain why.
Yeah.
Council.
Well, hold on a moment. I mean, part of my problem, go ahead. Yeah, come on.
Okay.
It starts. So council, I'm thinking 1, 2, 3, 4, 5. The first 6 pages, and then I think everything else should be excluded and returned. Would you agree with that? Or basically starting at the first photograph picture, so everything above that.
Your Honor, I think page 5.
Page 5. Let's see. Oh, okay. I see what you're saying. Yeah. So first 4 and then 6 should probably be part of it. Everything else should be.
Your Honor, towards the back, there's one.
I would be taking that. Is there one that you think should be in?
I think that.
Gotcha. Okay. So I would have 6 pages total. Right. Which would be a missed second, it says second notice in the top corner, and then it's accompanying page. That's the one that has abatement across it. Then I would have the stop payment, which would also be 2 pages. Then I would have the shelter association letter, and then the ledger. Is that right? All right. So I didn't look at it before council did. Can council give me everything back but that, or you can give me the whole thing back, and then I will just make a copy of these 6 for everybody.
Okay.
What do you want me to do? Just give everything back? Yeah. Just take everything back. And Ann, I'm gonna need you, please.
This might not sound like one of the dramatic moments of the hearing, but it's actually a perfect example of how experienced judges protect both the integrity of the case and the privacy of the people involved. As the witness hands over documents, Judge Simpson immediately notices that some of them contain personal information unrelated to the legal issues before the court. Instead of allowing every page into the public record, he carefully separates what is relevant from what isn't. That's not just courtroom housekeeping. It protects sensitive information while ensuring that only evidence connected to the dispute becomes part of the official record. At the same time, this exchange shows something equally important. The judge isn't refusing evidence, he's narrowing it. The letters involving notices, payment issues, and housing records remain relevant because they may help establish a timeline. Personal documents that don't advance the legal questions are removed and even directed to be shredded. That prevents unnecessary disclosure while keeping the hearing focused on facts that actually matter.
All right, so ma'am, what we're doing is you got some personal stuff in there. I got it.
I thought I got it all wrong.
No, it's okay. It's okay. So you understand what I did. I took everything like that out. The copies that we gave, I'm gonna have my staff shred.
Thank you.
Okay, and then, so that needs to be shredded and we need copies.
This is being shredded. This is what you need copies of.
Correct, correct. All right. So part of my concern, and you'll see it, counsel, when is that the landlord would have known that payment was stopping and the reasons for it, yet then filed a case against Miss Griffith on or about that same date of the stop. So payment was going to stop June 1st. Notification and as I look at it, went out May 24th. And they filed a case in June. Ma'am, but you moved out at the end of June, is that
Yeah.
correct?
I didn't move out by June 29th. So it was.
Well, and counsel, what is stranger to me in this is and then you can ask whatever questions you want regarding it. I'm looking at her file. And with the document she's presented on June 28th of 2024, plaintiff took a judgment for 2388.10, which she could not have gotten to unless the payments had stopped, which they had June 1st. Then an amended judgment was to be filed for 1177.10, which would seem to me to be, well, in July, the amended judgment was filed. Every other. So, Freeman, while I hear you in saying that you don't know about this, but what's clear to me based upon looking at her file is that your client did know about this. And despite just stopping payment, proceeded to take a judgment against her for not only her portion that she hadn't paid, but for the Mr. portion.
Now the hearing begins, moving beyond maintenance complaints and into questions about legal responsibility. Judge Simpson is carefully comparing the witness's testimony with the documents already presented to the court, and he's openly pointing out what appears to be a timeline that doesn't immediately make sense to him. According to the discussion taking place, the court is examining whether payment issues were already known before a judgment was pursued. Rather than accepting either side's explanation at face value, the judge is testing whether the paperwork and the testimony actually line up. This is where courtroom hearings often become far more complicated than they first appear. Dates matter, notices matter, the sequence of events matters. A landlord may have one explanation, while a tenant has another, but ultimately the court has to determine whether the documentary record supports either version. That's exactly why Judge Simpson keeps returning to specific dates and payment history instead of allowing the conversation to drift into general accusations. If the timeline doesn't fit together logically, judges are obligated to ask more questions before reaching any conclusion. That willingness to challenge apparent inconsistencies, regardless of which side they affect, is one of the most important functions of the court. The hearing is gradually shifting from emotional testimony toward documentary analysis, and that combination often carries significant weight when the judge eventually decides what happened.
Okay. And ma'am, was there a point where you had stopped paying rent?
No. But when you look at, I gotta.
Hold on, just hold on a second. I need you to answer my question though. In December of 20, we'll work with just 24. Did you pay rent to them and you paid your 165? You paid your 165 up to the month that you left.
Correct.
Some of this we had and you had submitted to the court already. Hold on, just hold on, okay? Ma'am, do you still have records of your payments?
I do.
Particularly from, can you do this? Wow. Would it be fair to say you did not, like you didn't pay 165, you would pay different amounts?
I would pay, big chunks at a time. So I was
Right.
never behind,
Gotcha.
because I didn't want to, actually, I didn't want to lose my place, so I was always ahead.
On your portion.
Correct.
Okay. Yeah, I'm sure you do. All right, hold on. So I understand you're saying your client may not know anything about it, but that can't be true.
Well, Your Honor, I did take a look though. I don't have the initial complaint that was filed back in May, but the complaint was filed in May of 24. The abatement didn't take effect until 6/1/24. So the numbers don't.
Right, but then look at the numbers that I'd agree with you on that's when the abatement took place. Notice of that abatement was prior to or about the same time as the filing of the complaint. That's what I'm saying. But then the problem becomes that on the filing of that complaint, they say she owes $772, I think is what I remember looking at. I'm not looking right at the complaint. But then that's on May 23rd. By June 28th, they take a judgment against her for almost $2,400. In July, an amended judgment was to be filed, and they still took a judgment against her for $1,177.10. Then, when it wasn't paid, at some point, plaintiff attempted to enter a dismissal, and I would not enter dismissal in the case. And it became part of these cases. So, I mean, they knew, I mean, unless I hear something different, but it seems to me that they would have known that her unit was not habitable, could not be, or that Mr. was telling them that they needed to fix it. And then they still sued her. And then when Mr. did what Mr. was going to do and say, we're shutting it off, they took a judgment against her for what Mr. hadn't paid, knowing that Mr. wasn't going to pay it because the repairs hadn't been
I all I can tell you is that as far as the proceedings that are pending here, they did attempt to dismiss the case.
Oh, I get why. Because she has claims. I mean, first of all, Mr. Freeman, and it wasn't you. I mean, because you had just come into this.
Listen closely to the direction this hearing is taking. Judge Simpson is no longer discussing isolated maintenance requests or individual repair problems. Instead, he's explaining why the procedural history of the case itself has become significant. According to the discussion in court, there was an attempt to dismiss proceedings, but the judge is now connecting that procedural decision to the broader testimony that's unfolding before him. One of the judge's responsibilities is ensuring that important factual questions don't disappear simply because litigation strategy changes. If testimony raises concerns that deserve closer examination, the court may continue exploring those issues rather than treating them as resolved automatically. That's why you hear the judge carefully explaining his thought process instead of issuing quick conclusions. This also demonstrates how courtroom decisions often depend on context rather than isolated events. A filing, a dismissal request, or a procedural motion may look routine by itself, but when viewed alongside witness testimony and documentary evidence, its significance can change dramatically. Judge Simpson is making it clear that he wants the full picture before deciding what legal consequences, if any, should follow.
But there's a reason why I swear attorneys in to take the default judgments. It's not by mistake. And
to be clear, Your Honor, neither this office, my office, nor Field Properties were involved in any of these transactions.
I get it, but you represent them now, for good or for bad. Ma'am, is there anything else you want to say to me?
Yeah, the second notice, well, the first notice on the, housing commission was April 24th, 2024. So they had April, May, June, they had 3 months to do the repairs.
Okay. Anything else? No? Oh. Any questions?
I have a question, Your Honor. At one point, you mentioned something about your oven or stove. Can you say more about that?
Yeah, the oven almost caught me to catch on fire. I called maintenance to come fix it. I have background to that too, but they never came, so I had to go get the stove myself.
You would install the stove yourself?
Yes.
And I understand, so it sounds like there was, with the flooding that you were describing, was that sewage water?
Yes, it was.
Okay, and what floor were you on?
I was on the main floor, and it wasn't from when I first moved in. Stacey was trying to tell me it was from the main upstairs because they would always be flooding. I did have somebody come and investigate it, and I did pay him $300 something to look at it. Then he had to come back and he told me that then he'll come if he has to, but they told me that the issue is bigger than what can be handled. That I was wasting my money to address this, to call somebody and see what we could do about it. And I did. I started calling a bunch of people. Housing commission, I was calling in. This isn't new, it's been an ongoing situation.
Were there certain times of day or anything where the flooding would occur?
When it rained, it was worse, but sometimes it would just happen. You can't control it. It's coming from wherever the issue was. That's where it was coming. Why it come came. Like I said, I went through 3 steam units.
You were on the first floor.
That's correct.
So were there 2 floors on top?
There's
or
my floor and then one more floor.
okay, is there sort of a basement, right? Okay.
The laundry room was always flooded.
What was the water?
The other sewer.
How do you know?
By the smell. It was awful. It's awful.
Was there anything visibly noticeable about it that you made it look like sewage?
Yeah. Yeah. It was sewage. Doesn't take much to get it out. It was just rainwater. They caved the whole ceiling in.
Which part of which ceiling?
When you walk into the door, my front door, right there. I have pictures of that too. It's all over the internet.
Did you have, I mean, that's obviously a huge issue. Were there other issues as well? Like, did you have
I had
hot
issues.
water consistently?
No, they have hot water. Sometimes they didn't have. I have letters that they sent out. They gave us little heaters. They never invested in anything. Nothing.
By this stage of the hearing, the testimony has become remarkably detailed, and that's important because the court is no longer hearing broad complaints. It is hearing specific descriptions of recurring problems. The witness has testified about flooding, sewage, leaking appliances, lack of hot water, maintenance requests, and conditions that she says continued without meaningful resolution. Whether every allegation is ultimately proven is a question the court will decide later. But what makes this testimony significant is the consistency with which the witness describes repeated maintenance issues over an extended period. Judge Simpson also isn't interrupting simply because the allegations sound serious. Instead, he's allowing the witness to explain what happened while making sure the testimony stays organized enough to compare with inspection reports, photographs, work orders, and any evidence introduced later. That's exactly how a factual record is built in court. Notice another pattern developing throughout this hearing. Several questions focus less on isolated repairs and more on whether problems were repeatedly reported and whether they remained unresolved. That distinction matters because courts often look closely at notice and response. If someone reports a condition once, that's one issue. If testimony describes repeated reports over months, the legal discussion can become very different depending on what the evidence ultimately shows.
Your Honor, I understand that the city inspectors have some photographs of when they inspect the unit and it,
This unit?
this particular unit. And so I guess I would defer to the court on how and when you would like to.
Well, I'll hear from them.
Okay.
Okay. Was there any other questions you had of her, Mr.?
I was kind of curious about her installing the stove.
Go ahead.
Did you have somebody install it?
Yes.
Who installed
A friend, his name is James. They wouldn't give me a stove. There was a couple people that had stoves in there.
it? You didn't have a permit.
No, I wish I did.
I do have another question, Your Honor. So my understanding of vouchers is that they use them or you lose them, they expire.
That is correct.
Do you know when the expiration date is for yours?
June 2007.
I'm sorry. Do you know when you have to place it? I might be misunderstanding. When do you have to place it by or you lose it?
June 2007. So when I had to use about the housing voucher, yeah, I just have to find a place, but it expires 2007. If I don't find it,
Is it 27?
yeah, 2027.
So my experience is that they typically will go for 3 months and sometimes are extended to 6 months.
That's correct.
in extraordinary circumstances, maybe a little bit longer. Do you know why yours would be so much longer than that?
Probably because of the situation. More.
But you're sure that you have your
Yes.
voucher.
Yeah, I talked to, Gracie, well, I talked to her in December.
Right.
When we were going to court, and then I just recently talked to her, because I asked her, I said, what am I supposed to be doing? She told me, just keep coming here and.
Okay,
do my-
so, okay, all right.
And what is preventing you from finding another place?
It's hard to find, it's really hard.
Do you think that the judgment might be affecting?
Oh, yeah, it's really affecting me a lot, because I mean, they want to know, they want to make sure that if you're renting, they just don't want to rent to somebody. That's basically what they say too. What was the reason? I give
So,
them all kinds of reasons, but it's just my word.
so ma'am, where are you living right now?
I've been back and forth, pretty much, I'm just couch cruising, but my mom was sick, so I was helping my mom.
I guess I would just ask to leave the record open on her particular cases. It sounds like she might have photographs that would be relevant. You can meet with her at another date, Your Honor. There's other questions.
Yes, so I guess I have a question for you, Mr. Raymond. Why shouldn't I order that she be rehoused?
I think that's up to your discretion, Your Honor.
Oh, I know, but I'm asking, I mean, my inclination is to order that she immediately be housed. So is there any reason I shouldn't order that?
I'm going to leave that to your discretion, Your Honor. I would say though that I'm not being argumentative here, but I'm not sure that the decision to not allow dismissal is doing her any good. It could be without prejudice to her having some claims. So I don't think that the case, the judgment against her, I don't think is working in her.
You mean the judgment that should have never been?
That was not a judgment that I entered, so I'm not going to.
Okay, but you mean that judgment that should have never been? Well, Mr. Friedman, you and I have both been doing this for a long time. I know that when landlords want to escape something that they've done, what they do is they file against people, and then all of a sudden, when things start to look bad, they want to dismiss them. It wasn't by accident that I didn't allow these cases to be dismissed, because the moment I would have dismissed her case, she would have never gotten here and told me that because of the circumstances at Arbor One West, this is the court's interpretation of what she's told me, led her to become homeless. And then I could then sympathize and empathize with her, but I could not do anything about it, like what I'm about to do, which is I'm going to order that Arbor One West rehouse her immediately. She is to be rehoused within the next 5 days.
This is unquestionably one of the biggest moments of the hearing so far. After listening to extensive testimony, reviewing documents, questioning the witness, and examining the timeline presented in court, Judge Simpson reaches an immediate decision on one issue. According to his ruling in this hearing, Arbor One West is ordered to rehouse the witness within 5 days. That is a concrete directive issued from the bench, not merely a suggestion or a recommendation. It's also important to understand what this ruling does and does not mean. The judge is not resolving every dispute connected to the property, nor is he announcing a final determination on every legal claim discussed during the hearing. Instead, he is addressing what he views as an immediate housing concern, while leaving other matters, including additional legal questions, to be considered later. That's a common approach when a court believes immediate relief is necessary, while broader issues remain under review. Notice how dramatically the hearing has evolved. It began with witness lists and procedural scheduling, then moved into testimony about living conditions, payment history, relocation issues, and documentary evidence. Now the court is issuing a direct order that could have an immediate impact on the witness's living situation. This ruling also signals something about Judge Simpson's approach throughout the hearing. He has repeatedly emphasized gathering facts before acting, But once he believes the record supports intervention on an immediate issue, he is willing to make a decisive ruling from the bench.
Your Honor, would the court consider setting aside the judgments that were previously entered?
I'll consider that at a later time. Right now, I want her in housing. She should be living like she's living. Okay.
Your Honor.
What I'm gonna do is I want, would have you talk to the folks at Legal Services. They'll operate through Legal Services in terms of her rehousing.
So if she wants to give her contact information and everything to legal services, we can work through them, but we don't have any contact information for her.
That's because she had to move and she's homeless. I get it. So that's why I'm gonna ask Legal Services to help her with this. Okay, Ms. Griffin? All right. We're probably gonna need you back for other testimony and everything, okay?
Yeah, I'm here.
All right. Thank you.
Thank you.
All right, so I have 1, 2, 3, 4, 5 additional witnesses that were on our list. Is that right?
I'm sorry, Your Honor.
I
I'm so
know.
sorry.
I know, I saw Ms. Kim was in your ear. I have 5 other folks that are on the list.
Okay, yep, that matches my.
That's last, okay. Are those individuals still in Arbor One West, or do we know?
I believe that at least 2 of them for sure have been offered relocation and taken it. I'm not sure about the others.
If you names, I can tell you whether they've been relocated.
Miss Harris, Freeman Harris, are you still in Arbor One West unit?
No, I'm in the building right now.
You're in the villa side.
Yeah,
And you keep raising your hand, but who are you?
Yeah.
And were you going to want to testify before the, okay. But I don't know if you're on our list, however, but. Huh? You're letting Miss Grove in. Okay. And then
first name is Sherelle.
Sherelle,
No, she already testified.
I was the first one.
you, but what?
I was the first one, but I thought you were gonna have us answer specific questions, and I actually wanted to say something. That's all we got time.
Okay. So you have more that you want.
I do.
All right.
All right, with respect to Gamble, she testified. We examined her. She was subject to cross-examination. I would object to having any more testimony from that witness.
Your response on that?
Your Honor, I will just say that this is an evolving situation, and I think she may have her own testimony, so if there's something more she'd like to offer, then I encourage the court to consider that. There's also one other tenant here who has just joined.
Just joined.
I'd like to ask, but he's here.
Who is that?
Mr. Jeffrey Thompson.
The courtroom has now entered a different phase of the hearing. Up to this point, the focus has been primarily on tenants already connected to the proceedings. Now, the discussion shifts toward whether additional individuals should be allowed to testify at all. That may sound like a procedural dispute, but it's actually a critical question, because every new witness has the potential to either strengthen the existing record or introduce entirely new issues for the court to consider. Judge Simpson is balancing 2 competing concerns. On one hand, the parties have a legitimate interest in knowing who will testify and why. On the other hand, if additional tenants possess first-hand knowledge that could help explain the conditions being investigated, excluding them too quickly could leave the court with an incomplete picture. That's why you hear objections, responses, and careful questioning before another witness is permitted to take the stand.
He's not a litigant, but he has relevant information.
Who is it?
Jeffrey Thompson.
Jeffrey Thompson. But he's not a litigant.
Correct.
Where's Mr. Thompson live?
723 Green Road.
Miss, I'm almost afraid to ask this question. Miss Harris, I realize you're not under oath. But when you moved, did you pay a security deposit? A new one? Okay. Pardon? Not right now. I just needed, I needed that just as a preliminary thing for my thought process. Okay. Okay. Did you want to look up any of those individuals or anything prior to them coming forward or?
Well, as far as Jeffrey Thompson's concerned, frankly, I don't think his testimony should be allowed. He's not a litigant. He's not subject to the show cause. We don't have, the field properties didn't have any information about this person to do any work or not do work. They certainly.
They did presented multiple city inspection reports.
Oh, sir, not how we work. Okay. Understood. Well, part of the problem is that they can become litigants in a minute. And that's what I've been suggesting to legal services to do on their behalf, because quite frankly, I've got individuals in buildings. I realize they may not be specific litigants to these cases that I have before me, but I think to the extent that they're going to provide to the court relevant testimony, I'm going to accept it. So I'll give you a chance to look up what's the deal with his apartment. Plus, I think 723 Green, that was condemned, right? No, it was not. It was yellow tag.
Your Honor, we do have a complaint that we are prepared to file on behalf of Mr. Thompson, which may happen today.
Gotcha. So I will certainly hear from him, at least at this point. I realize he may not be the subject of these particular ones, but it's becoming rather messy. Were there any other individuals out there who are tenants who wanted to provide testimony to the court that are sitting out in the gallery?
Mr. Blankenship is actually the court.
Mr. Blankenship, where are you? Oh, right. Okay. All right. I'm likely going to have to go back through. I promise you folks in the city of Ipsy, I will get to you, but I want to get to tenants first.
Since we don't have a lot of time, I was hoping we could start with Rico Wire, as I think it will be short.
Didn't she testify?
She did testify.
Was that her that wanted to add? No, that was somebody else.
It's a different individual. She is the, she lives there. She's the mother of another litigant, and she has just more testimony to give about what has happened since we met when she last testified. But I think, Your Honor, I think it's relevant to the relocation efforts, and that's why we're reading it.
There, she's testified that she's been relocated, and she's not living.
She is relocated.
She is relocated.
So I'm trying to figure out what would she add to. I mean, give me a proffer of what she's going to say.
She will testify to what happened to her belongings that were left in the old unit before she had turned over keys. She'll testify to having the process of relocating to a new unit with a housing choice voucher, and how that isn't working properly and well. And she'll also testify to issues with the new unit that's unique to her particular circumstance.
She gets moved to another part. I want to hear from some of these folks I haven't heard from. I mean, I'm not saying no, but not right now. I mean,
Okay. The books are in the hallway, so.
I need Miss Harris Freeman.
Okay.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and the true self you got?
Yes, sir.
Let's see. Thanks for your first and last name for the record. please.
Angelina Harris Freeman.
Thank you.
EDWINA. I have two last names. First one Harris, HARRIS. Second one Freeman, FREEMAN.
Thank you. All right. All right.
Ms. Harris, what was your previous address?
815 Green Road, apartment 303.
A new witness means a new opportunity for the court to compare testimony against everything already placed on the record. Before diving into allegations, Judge Simpson follows a familiar pattern, confirming identity, previous residence, and current circumstances. It may seem repetitive to viewers, but this consistency serves an important legal purpose. Each witness must establish their own connection to the property before discussing conditions inside it. That ensures the testimony rests on first-hand knowledge rather than assumptions or second-hand information. As this witness begins describing her experience, notice how the judge allows her to explain events in chronological order. That structure helps the court compare her account with inspection records, maintenance requests, and the testimony already heard from earlier witnesses. If multiple people independently describe similar conditions over similar periods, the court can later evaluate whether those accounts reinforce one another or reveal meaningful differences. This is also where credibility starts being tested naturally. The witness isn't being asked for legal conclusions. She's being asked to explain what she personally experienced. Those first-hand observations often become some of the most important evidence in hearings involving housing conditions because they provide context that paperwork alone cannot always capture. The next series of answers could significantly influence how the court views the overall condition of the property and the responses that followed.
Where do you live now?
I live at 429 Villa Drive.
You relocated?
Yes, sir.
Yes, you're now in the township.
Yes, sir.
What unit are you in?
I'm in a townhome. Or do you want to know what type of unit I was in?
I think you were in a unit 815, 303.
Yeah, that's the unit we're speaking about now.
That was red tag. You were relocated pursuant to.
Right, I'm asking you, are you asking me what unit I was in? Because I was in a 2-bedroom apartment. Or are you asking me what unit I'm in now? Because I'm now in the town.
Yes.
Okay.
What kind of a unit is that?
It's a townhome.
How many bedrooms is it?
2.
I don't have any questions. We did look to court order. She's still looking.
Would you like me to explain to you though my time?
Hold on. Just a second. Hold on. I'll get to it.
Okay.
Any questions, sir?
Sure, Your Honor. Ms. Harris, when did you move to Florida?
October 7th, 2023.
And can you briefly describe some of the repair qualities?
I sure can. So when I moved in, the first thing I noticed was my stove. Or not my stove, my dishwasher. I apologize. My dishwasher would leak. Anytime I would turn it on or try to run it, it would leak and overflow. I filled out several maintenance. Maintenance is kind of choppy, so sometimes they would come out and like drain it, but it would go right back to being a flooding situation. I had a family member that worked for the maintenance. He came in and actually took like a vac to it, like some type of like a wet vac, I think. I don't know. Got everything out and it's still. So this dishwasher would just sit here and leak all onto my carpet. And then eventually, instead of it leaking, it filled up with sewage in the bottom of it.
The bottom of the dishwasher?
Yes, the dishwasher. So I kept it closed. I even had it closed when the city came out to inspect it. And when you opened it up, I'm like, listen, please don't, because it stinks so bad. I just kept it closed because the smell was horrible. Next thing was my tub. My tub handle didn't even work properly. Like I almost had to take like maybe like a wrench to try to get it to turn to turn my hot water on and off. But still same thing with my tub. My tub would fill up with sewage, frequently. My toilet was my next thing. I had toilets backing up. I would have maintenance come out. They would plunge the toilet I guess in September. I had maintenance come out because both of my toilets were clogged, and he told me, hey, like, well, you're about to move anyway, so there's no need for me to fix this other toilet. Just use the one toilet that you have. I have 5 girls.
Okay.
It's not ideal.
No.
What age?
Well, I have 5 kids total. I have a 13-year-old, I have a 12-year-old, I have a 6-year-old, I have a 3-year-old, and I have a 1-year-old.
What other problems did you have? Your problems with your heat?
I had problems with my heat and my air conditioner. Summertime, I had just had this one baby, and my heat was at 99 when it was 99 outside. And then, of course, wintertime, I had problems heating up my unit. I called them multiple times. I put in multiple work orders, which I give you guys special proof of. And they failed to come and get my unit together. And quite frankly, it's just embarrassing. It's a sick way to live. It's sick when I have a 3-year-old who I come home from work and she's playing in fecal matter water. Like, it's disgusting.
And did you miss any work?
This question expands the hearing beyond the physical condition of the apartment itself. Instead of focusing solely on maintenance issues, the court is now exploring whether those alleged conditions had practical consequences in the witness's daily life. According to the testimony, the discussion includes missed work, medical concerns involving family members, and the challenges of caring for children while dealing with repeated household problems. From a legal perspective, these questions help establish the broader impact the witness claims resulted from the living conditions she described. Judge Simpson still isn't making findings at this point. Instead, he's allowing the record to develop so that any later decision can be based on specific testimony rather than general impressions. Another noteworthy aspect is the level of detail being provided. The witness isn't speaking only about broken fixtures. She's describing how those conditions allegedly affected her routines, employment, and family responsibilities. Whether those claims are ultimately accepted depends on the totality of the evidence, but they certainly add depth to the factual picture the court is examining.
I would say in total, soaking up my floor or taking my kids to the hospital, because like after that happened, I wanted to make sure she was okay. I would probably in total throughout the whole time I lived there, probably miss up to 10 to 15 days. Longer than throughout the house.
And where did you work?
I work at Outback Steakhouse. I'm a bartender, server, and a shift manager.
And where was your unit yellow tag?
My unit was yellow tagged in September, around the same time she was harassing me, telling me I needed to leave. And it got condemned, I want to say, what, 2 court cases ago? 2 court cases? Yes.
What's February 23?
Yes.
And so now, across the street.
Yes, thanks to Judge Simpson, he court ordered it, he heard my problem, and got me in my family.
And before you were in the villas, you were in the hotel room?
Yep, I was in a hotel room from Friday to that Monday. Friday, she called and let me know that I could get you a hotel. And then she called me back and she said, hey, on Monday, I want you to come pick out whatever apartment you want. And we'll get the keys. I went, looked at 3 apartments, I picked out the one I wanted. And I didn't sign a lease. I haven't signed a lease yet. I have no paperwork for this place, but I moved me and my kids to this apartment. And this apartment's no better than the last one.
Can you tell us what problems you have?
I've also put in several work orders for this unit. I had a heat issue. They did come and fix my heat, but I also have issues in my bathroom. Who told me I would need a new toilet. This morning, my toilet stopped. I took a camera of that, so my toilet's now backed up from one toilet I have in this unit. My tub, I don't know if this is gonna make sense. So my tub runs from the spout and the shower at the same time. So the water pressure is either too hot or too cold because it's not all coming out of one area. So when we're taking a shower, it's either the hot water is running out, but it's too hot to begin with, so I have to let it run out and the kids can't take an adequate shower because it's not long enough, or the water's too cold. She said that he needed to come and remove the panel from behind it. And they still haven't come to do that. But at this point, I just take pictures and move on with my day.
What was she said?
Lynetta, yeah,
Manager?
yes.
And how many days were you without heat in the evening?
About 3.
And was it just not heating up enough or you had no heat?
They said it was blowing, but it wasn't heating up. I don't know if he lit or relit the furnace. The furnace, yeah, the furnace.
Maybe you also like to share about your experience in your
I would just like to say that my whole experience has been mostly dreadful. I moved in, it was a place for me and my kids to stay, and have shelter, and it just was like, it was worse. It was a worse situation. And I paid my rent every month, so.
This testimony marks an important turning point because the witness is no longer talking only about broken fixtures or maintenance requests. She's explaining how she believes those conditions affected her family's overall living situation. According to her testimony, she paid her rent while experiencing what she describes as increasingly difficult conditions. Judge Simpson has consistently allowed witnesses to explain their experiences fully before evaluating them against documents, inspection reports, and testimony from other parties. One thing that stands out throughout this hearing is that the judge repeatedly separates emotion from evidence. Emotional testimony alone doesn't decide a case, but neither is it ignored. Instead, it becomes part of the factual record that must be weighed alongside written notices, inspection findings, maintenance logs, payment histories, and every other piece of admissible evidence. That careful balance is exactly what the court is trying to achieve. The witness also raises an issue that appears repeatedly throughout this proceeding: the belief that she fulfilled her own obligations while expecting the property to remain safe and livable. Whether the evidence ultimately supports every aspect of that position is something Judge Simpson will decide after considering the entire record, not just one witness's account.
I kind of felt like I was being bullied to get out of my unit because of what they were going through, not because of anything that I did.
Yes.
No, my kids, I wish I had my daughter with me. My daughter's 13, she has friends, and them coming over was embarrassing to her because the house smelled like sewage. Not only did the house smell like sewage, the downstairs and entry when you first walked in, their unit down there had flooded with sewage. So it's a waft of sewage when you just walk into the apartment building. Absolutely disgusting.
When did you, I'm sorry, Ms. Kim, were you?
Oh, no, go ahead.
When did you, well, your lease expired in October 2024.
Yes, sir.
And you had been, but your building was tagged in September, correct? Yes?
Yes, sir.
Okay.
Sir, can I say one?
Yeah.
Okay. I moved into a 2-bedroom. I was pregnant with my last child. Stacy, the lady who got me the apartment so that I could add my kids on my lease later after the baby was born. After my baby was born, I went to the leasing office. I said I needed 3-bedroom. She tells me to bring her a $2,000 check to move into this 3-bedroom. I bring her the $2,000 money order to move into my 3-bedroom, and she tells me she does not want me to stay here anymore. I said, why? She said, I don't have to give you a reason. I said, okay. I said, well, I don't think this is fair because I have all of these issues, and I just came with you with a $2,000 check that I probably shouldn't be getting. She said, well, I won't be on court. And that's how I ended up here. If you look on my ledger, I have paid all my bills.
No,
In
that's,
total.
but it wasn't your case that the payment wasn't an issue.
Okay.
What was the 2,000 for?
It was a transfer fee from my 2-bedroom unit to my 3-bedroom. So she never accepted it. And just told me that she wanted me and my kids to leave.
And all during that time, well, hold on a second. Your unit was yellow tagged what day? Do you recall?
I'm unsure of the date that it had the yellow tag. I wanna say, it was in September sometime.
Okay. Currently, where are you paying rent to? And to whom?
So for this month, I'll put my money in that.
You're putting it in because we had talked about that.
So here's my question, you, what rent am I paying?
Yeah, he asked me another hard question.
I don't know. I mean,
Pay what you were supposed to be paying at the other.
Oh, okay.
Okay, into court escrow. All right, that's the best answer I can give you. All right, okay. Anything further from either side?
I'm trying to get the timing of this, Your Honor. It sounds like you didn't really have a unit that was up to snuff, so to speak.
Correct.
From the day you moved in.
Correct.
And then your lease expired a year later. And they asked you they said they didn't want to renew.
I think that's what I said.
But you didn't want to leave.
No. That's not what I'm saying. What I'm saying is, you don't think I didn't want to leave. I wanted to leave into a 3-bedroom apartment where me and my kids could live comfortably. And that was the option I would get. And then when they decided that they were going to go through whatever they're going through, now she doesn't want to accept my money. But I just sat here and lived 365 days with 5 kids in a unit that wasn't intact. So no, I wasn't about to go anywhere, because where was I about to go? If my plan was to move across the street to a 3-bedroom, where was I going?
Well, I don't know.
Oh, okay.
My question is, did you look, did you see?
Why would I be looking for anywhere else if I was told I
I'm
was
asking
getting a
you a
3-bedroom?
question.
Let him finish his question.
Did you seek housing outside of Arbor One at any time?
No, sir.
So you never looked at any other apartments, any other complexes, any other homes? You just wanted to stay with Arbor One this entire time? Is that correct?
Yes, I was going to stay with Harbor One, which is why I brought her a check, so that I could move into a 3-bedroom, correct? Is that what I just said?
This exchange is one of the more revealing moments in the hearing because it addresses a question that naturally arises from the earlier testimony. If the living conditions were so difficult, why didn't the tenant simply move somewhere else? Rather than giving a simple yes or no answer, the witness explains that, according to her testimony, she believed she already had a path forward within the same housing complex through a transfer to a 3-bedroom unit. That distinction is significant because it changes the context of the discussion. Judge Simpson doesn't immediately accept either side's interpretation. Instead, he allows the explanation to develop before comparing it against the broader timeline already established in court. That's consistent with the way he has handled the entire hearing, letting witnesses explain their reasoning while reserving judgment until the surrounding evidence has been fully considered. This also highlights how housing disputes often involve practical realities that aren't obvious from paperwork alone. Decisions about relocation may be influenced by family size, financial limitations, available units, and the difficulty of securing alternative housing. Those real-world considerations don't replace legal analysis, but they can provide important context when the court evaluates why certain decisions were made.
Okay. Why would I look anywhere else? If I was.
Well, hold on. Stop with your questions. Go ahead.
I'm struggling with the fact that your complaints about Arbor One have apparently existed since October of 23, and yet when you were invited to move out, non-renewal of your lease, you chose to stay anyway.
Is there a question in that? Hold on. Is there a question in that?
Is that correct?
Go ahead.
So,
Well, I think based on her testimony, in part, that's correct, Mr. Friedman. I mean, I get what you're saying. What I'm having a problem with, and I mean, you can go ahead and ask the questions, is that in September, the building, she's existing in all of these conditions. The building is yellow tagged in September. It still doesn't repair it. Rather than fulfilling their obligation to repair her unit and or to move her, they file a complaint to terminate her tenancy. That seems to me to be more problematic than her not searching around trying to figure out where she's going to put her and 5 kids.
I understand your point, Your Honor, but at the same time, the complaints seem to have started in September of 23.
I get you, Mr. Friedman, but here's the thing. We all understand the housing situation here in Washington County, right? Hers is going to be particularly unique because of the number of children that she has in terms of trying to find housing, right? So she ought to be able to exist in some place that is at least habitable and at least try to do the best she can. She's then offered a 3-bedroom, which is really her point. She's offered a 3-bedroom, not searching any place else because that's going to be hard to find. It just is. So I get the 3-bedroom because at minimum, at least, I can have a roof over my head with the 2-bedroom. Am I right? Am I right? So then it's a 3-bedroom that's kind of a godsend in a way because maybe I can get out of this mess I'm in, have enough room for me and my kids, and move. And then they won't do that. But instead of not doing that, after her building gets yellow tagged, they not only won't move her, you got to pay us $2,000. Kind of bizarre, but whatever. You got to pay us $2,000. And then what we're going to do is tell you, knowing that your difficulties, knowing that your back is against the wall, we're not taking your $2,000. We want you to leave. And you've got to move out. That's what they did. I have a very clear picture of what they were doing. She was a problem. And they had a problem. And so the way to get rid of that problem is to try to have that unit vacant. So if I can kick her and her babies out, then I'm good. That's what they were doing.
This is easily one of the strongest statements Judge Simpson has made during the hearing. After listening to multiple witnesses, reviewing documents, and questioning both sides, he's explaining his interpretation of the sequence of events presented in court. Notice, however, that he carefully frames this as his interpretation of the evidence before him at this stage of the proceedings. That's an important distinction because judges are expected to explain the reasoning behind their observations while the record is still developing. From the court's perspective, the concern isn't simply whether repairs were delayed. The judge is connecting several issues together: the reported condition of the unit, the discussions surrounding relocation, the proposed 3-bedroom transfer, the request for additional money, and the later effort to remove the tenant. Whether every one of those facts ultimately leads to legal liability remains a matter for the court, but Judge Simpson is making it clear that he sees a pattern worth serious scrutiny. One of the reasons this hearing has held so much attention is because every witness has added another layer to the timeline. Instead of isolated complaints, the court has heard recurring themes involving maintenance, inspections, relocation, and communication between management and tenants. Those recurring themes are exactly what the judge is now evaluating collectively rather than individually.
Well, Your Honor, I suppose that's subject to interpretation, but I guess it's your.
And it is my interpretation, and I'm going to be the one deciding it. So
I should state for the record that I'm certain I answered counter complaint for the defenses today on her behalf.
okay.
Working my clients.
All right. Very good. Anything else?
No, I just spoke with Inspector Joe Myers and clarified that in September, the building lost its certificate of compliance. In January, it was relative. Just to clarify.
So in September, it lost to COC and then was yellow tagged in January. And after losing the COC, rather than repair, they were trying to kick her out, which actually makes it even worse. But okay.
Pursuant to your order, a few weeks ago, she was,
The one you guys wanted to comply with, or the other ones? I'm kidding. Go ahead.
bottom line is, Your Honor, it's the show cause for progress.
I understand.
We ordered her relocated, rehoused, and within hours, she was offered and received hotel rooms
Yes.
and then was relocated across into the township. So as far as the show cause is concerned, I believe that the orders of the court were followed. Period.
All right.
Your Honor, if I may, the order was, I believe, entered on February the 4th.
Oh, I know.
Later. None of the repairs have actually been done. So plaintiff was in violation of the court's order. They did eventually relocate her when this was red tag. As Mr.
Well, they located her. They relocated her because she happened to stand up in court and tell me, which not everybody's had an opportunity to do, but I heard her, and that's when I ordered that she be relocated because everybody was acting as though she wasn't a human being and had to exist that way. Hey, that's how that happened. I would agree with you, Miss Kim, because they relocated her doesn't mean that the show cause in its entirety has been complied with. What has been complied with is the court's order to relocate her and put her someplace where at least she can have some semblance of dignity in living.
And finally, Your Honor, we ask for the order to help the repairs.
Okay, so this is where it's going to get into a bizarre cross-jurisdictional thing because the unit that she's in now is in the township. Pardon? Well, I'm not telling you to go anywhere. I'm just saying it's in the township. I could order that. The issue of its enforceability is going to be something that has to be looked at. So. All right, thank you. Anything else? You may step down. Let me just first say, I appreciate all of you coming down and being here. And the court sometimes can operate very slow, but I'm also trying to make sure that I hear from all of you.
After several emotionally charged exchanges, Judge Simpson deliberately changes the tone of the courtroom. Rather than ending the hearing abruptly, he takes time to acknowledge the effort made by everyone who appeared to testify. That might seem like a small gesture, but it reflects an important part of judicial responsibility. Many of the witnesses have waited for hours, returned to court multiple times, and shared deeply personal experiences under oath. Recognizing that commitment helps reinforce public confidence that their testimony is being heard and considered. The judge also offers viewers a glimpse into the practical realities of running a busy courtroom. Unlike television dramas where every case finishes neatly in one session, real courts often juggle criminal dockets, civil hearings, weddings, emergency matters, and countless scheduling conflicts. Those logistical realities don't diminish the importance of a case. They simply explain why complex proceedings sometimes require multiple hearing dates. This moment serves as a transition rather than a conclusion. Although significant testimony has already been presented, Judge Simpson makes it clear that additional witnesses still need to be heard before the court can fully evaluate the issues raised throughout these proceedings. It's a reminder that thoroughness often requires patience, especially in hearings involving numerous parties and extensive factual disputes.
And you have to, I mean, you can see it. I'm trying to listen to everything and trying to understand what's going on in each one of the cases. My docket is an extensive one. And so I've got to try to find a way to fit you in because you come down I have to break or I have to go do something else, and then I have to have you back. So, so I'm gonna have to break at this point. I've got a docket, another criminal docket that comes up at 1 o'clock. I mean, I'll just share with you everything I have. I would have you back after that docket. It shouldn't be long, except that then I got to do a wedding at 3 o'clock. And so it's already scheduled. I'm not telling those people no. Right. So, and then I could come back. It's probably going to be better. And I apologize to all of you if I just give a date for everyone to come back. We will have weird breaks in the docket, but at least try to set a date that I don't have much else. And so even though we had the breaks, I can just keep going and I can hear from all of you. Give me a date. I want it sooner than later because let me ask this. Are there any of the individuals here that are preparing to testify before the court that have something immediate that needs to be dealt with? You just raised your hand. No, you want me to talk to you. No, I'm not talking. Okay, so I see no hands are raised where it's immediate, but I need something relatively soon.
I got something to say.
But what did I just say? I said I will hear from everybody. I just want to make sure that those that I need to hear from today, that I try to get them heard. Okay. So it's not that I won't hear from you.
It's Monday, the 14th, in the afternoon after jury selection. Don't have anything. For that, it would be until the 21st.
I want to do the 14th. Is Monday the 14th available for the parties? Let me ask you that.
It is for me.
In the afternoon. Okay. Will that work for you guys?
It works for us.
All right. So what I will do is I will adjourn all of these matters to Monday, the 14th. What? No, that's at 1 o'clock. All right. Thank you, folks, for your patience. Bye. What do you just want to, you're like her with that gold Adidas thing. You just want to talk to me. What?
So look, I got a question. So look, I got my old neighbor, right? They had a washer and dryer. They told me they don't provide washer and dryer.
All right. I'm going to tell you, I hear you. There's nothing I'm going to be able to do with that right now. Okay. When you come back and we get you in here, then I can look at it and try to address it.
As this hearing comes to a pause, one thing is unmistakable. Judge Simpson has made it clear that this case is far from over. Throughout today's proceedings, the court heard extensive testimony from multiple tenants, carefully reviewed housing records, questioned timelines, examined payment issues, and scrutinized the condition of the properties in remarkable detail. Rather than rushing to broad conclusions, the judge consistently focused on building a complete factual record before making decisions that could significantly impact the lives of everyone involved. One of the most significant developments came when Judge Simpson ordered that a homeless tenant be rehoused immediately, demonstrating that when the court believes immediate relief is warranted, it is prepared to act decisively. At the same time, the hearing also showed that many larger questions remain unresolved. The court will continue examining whether the reported living conditions, relocation efforts, inspections, and legal actions taken by the parties complied with their respective obligations under the law. Those issues will ultimately be addressed only after every relevant witness has been heard and every important piece of evidence has been considered. Cases like this remind us that justice is rarely quick, but it is meant to be thorough. Every document, every witness, and every question asked from the bench plays a role in helping the court reach a fair and informed decision. If you found this case as shocking as we did, Make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.